Thank you for the opportunity to give this talk. I guess my credentials are to make me qualified. Limited if you ask my family, but I do lecture at Harvard on the topic, as well as bachelor's, master's computer science. Worked and sold in some technology and AI. Back in the day, I tell people, I told them I was in the PhD program, computer science, and I told my graduate advisor, because it's doing AI, this is garbage, it's not going to go anywhere. And then he's on the cover of Wired magazine about 8 years later. Little did I know. But you win something, and then I picked up a law degree. I've written a couple hundred articles, several textbooks cited by courts all over the country. I also resolve large disputes involving complex platforms, involving privacy, and I also was the chief architect for the rules for JAMS, which is one of the largest dispute resolution organizations in the world on AI platform-driven disputes. So I'm somewhat familiar with this topic. I like it to be interactive. I thought there'd be like 5 or 10 people, not this many, but if you do have questions as we're going, please just walk up to the microphone and ask them. If it's going to be stump the speaker, just remember, not everybody in the audience cares. So, I may sideline your question, but if it is of something the collective group would be interested in, please do stand up and ask. Questions are how everybody learns. This is an area where there's lots to learn. We'll kick it off. Here's the standard disclaimer. I won't read it out. It's really long, but it basically says, good luck. We'll just get started with the basics. AI represents a lot of issues, right? And it's going to eventually permeate all of our society. Maybe, some people say tomorrow, some people say 3 years, but at the end of the day, this technology is here to stay, and it's coming to play. Important thing you have to remember is the law isn't like the TV show like Law and Order, where in 45 minutes with a couple of ding-dongs, we're done. It runs 5 or 10 years behind technology. Right? Now this is really interesting, right? Because we're making policies and we're doing all of these things right now. And there's a lot of legal issues that come into play depending on where you sit, right? The federal government, civilian, Europe, right? EU passed the AI Act. You have executive orders from the federal branch. There's a litany, a smorgasbord of people that want to have a say and a voice in guiding the conversation. When you think about it, there's different sort of buckets of legal issues. Privacy and security, right? How do you protect the information that's going in? How do you secure the information? How do you make sure you're protecting the trade secrets? Right? So there are many different lenses just to look at these constructs, right? And who's liable, right? And we'll look at some scenarios and walk through these. But I think, and then you have transparency, explainability, and accountability. So most people here took an airplane to get here, right? Yeah, I hope. Well, I did at least. And when I get in the airplane, it goes down the runway, goes in the air, this tin cube, this tin thing, this little circle thing, it launches me in the air and I land. But lucky for me, there are aerospace engineers that can tell me how it takes off. They can explain it. There's transparency, right? We're looking at Boeing, they're experiencing radical transparency. Right? But there's transparency, like how an airplane works. There's transparency, right? I feel comfortable sitting in the 737 as long as the door doesn't shake. No, but, and there's accountability, right? There's a whole set of regulations. The FAA has created a litany of regulations about who's responsible for what, and then, the supply chain has regulations, all of this, right? In AI, there is none of that. You get a box and they're like, trust us, this will land the plane. Don't worry about it. And then there's like 100 people in the world that actually know how the box works. And then even within the 100 people, they have to spend a substantial amount of time to figure out how the AI actually works. It's not like the airplane. So we have a lot of legal steps and policy steps to evolve, so it's sort of like the airplane. But we're going to let a fully autonomous vehicle drive itself, no questions. But getting past the sarcasm of it all, that's a real set of legal issues, right? And there's a whole set of law, both the United States, Europe, and even in Asia that's starting to develop around this, right? You have policies, you have NIST. In the United States, we have some NIST standards that are coming out, executive orders. There's a litany of things, right? But eventually, we're going to need something like the FAA and like an airplane, right? That's where we're going to have to end up. And then you look at intellectual property protection. So a good friend of mine, Dr. Abbott, he loves to do the AI litigation. So he took the AI copyright suit to the, and it's interesting outcomes, because if you look at what happened in the United Kingdom with AI and the courts, it's much different than what's happening in the United States. You can't copyright AI-generated stuff according to the Copyright Office. In the UK, they're taking a different lens. And it'll be different around the world. And then, but how do you, that's one version of intellectual property. The next version is, how do you actually, can an AI create a patent? Right? There's this whole esoteric conversation around patent law. Does a human have to participate? Right? Courts are going to have to figure that out. Right? Judges are going to make some rulings. The patent office, Congress may pass a law clarifying what it's supposed to say. But you have this whole area. Okay? And then fairness and acknowledgement of bias. So if you ask my kids, I have 2 young kids, I am biased and unfair at least 90% of the time, right? I'm always nicer to the younger one versus the older one. Probably some truth to that, right? Now, that's my prerogative because I'm the parent, as I tell them. But in the world of business and the world of transacting and selling goods into streams of commerce and to engaging into these things that AI will be doing, it becomes a lot more important. Like if you're going to use AI like they do in China to automatically adjudicate tickets. So in China, there's actually systems where there's no traffic court judge. You submit your claims to the AI agent, and it adjudicates the whole thing. Now, there's a lot of pros to that and a lot of cons to that. It's all contextually based, right? It's all based through the lens of which you look. And when you think about it, right, making sure that system isn't like, oh, Daniel's driving, boom, he's going to jail, right? Versus, someone else driving, oh, they're okay, right? So there's these real problems that you have to start thinking about the biases that will likely exist in all types of applications of it, whether it's hiring or traffic court or writing, whatever. And that's in a whole other interesting area, right, that needs to be thought about, like sentencing guidelines. In the United States, there are sentencing guidelines for how you determine whether or not someone should or should not and how long they should go to prison. So and it's very complicated. So you're going to create an AI agent that will make a recommendation to a judge who will then evaluate that. Well, what happens if the AI that's being used is is biased, right? The implications are huge, right? So you're going to have to, again, the legal system's going to have to figure that out. And then inclusiveness, well, newsflash, your system, I'm sure you heard a bunch of people, we're only as good as the data we put in, right? Okay, great. So the point is, obviously, bad data, bad outcome, can't fix. It's like you can't cure stupid. You can only teach it how to ask better questions, right? That's just how it works. And same applies. So you have to make sure that the system itself and the legal system has to make sure that it is, when you're delivering these complex technologies, that they are properly working in an inclusive nature, right? Because we're relying on them for what, a traffic court judge used to be judge would evaluate, make sure all the information, versus a bot that just sits there and has every traffic ticket that's filed in a province and their driving history and all of this data about them and whatever else, right? How do you make sure that it's properly working? And then reliability and safety, right? Just driving a car and say it's fully autonomous mode and there's an accident, right? Who's liable? The driver, the manufacturer, the software engineer, the person who was supposed to secure it, right? Where does the line get drawn? Right now, it's the driver. Maybe sometimes the auto manufacturer, right? If it's brakes or car bags. No, okay, I'm not gonna pick on anybody. But the point is that these are real things that the law needs to evolve to address. So that's a whole lot of stuff. So what I did, rather than us going through all the really boring laws and all the really boring court cases, I figured we'd do like a scenario based. And if you have questions, feel free to ask. Here's a scenario, privacy scenario. So you're a healthcare organization. Your CEO was using generative AI over Thanksgiving, and she got really excited, and she told her team, build me the most razzle-dazzle healthcare AI application. So she gives the marching orders, right? AI is very interesting, right? Because most IT projects are like, you go to the CEO, oh, we need budget. Give me the business case. Okay, blah, 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 blah. All right, well, I think that may work. And then you roll it out. Do we have to do that? That's so inconvenient. Versus AI, when they're like, oh, this is amazing, CIO, go do it. Right? It's a totally different conversation, right? This is being fully driven by the business. Businesses aren't excited about 2FA. They're just not, right? Like 2FA, yeah. No, like, but the CEO or the head of this healthcare company, she's really excited about what it can do, right? For diagnosing and helping patients, right? And let's say they're doing a slide for their radiology, right? They're doing slide review, right? Because they're saying AI will replace pathologists at some point because they have the ability to be more effective and accurate in diagnosing cancer and other things, right? So it's a very real, she's really excited. She's like, great, I can never hire another pathologist, and I'll still print money because I can bill the Medicare, Medicaid at the same rates with none of the labor costs and everything else. She's super jazzed, right? And she builds it and they roll it out, right? And then it's found to be collecting all the patient's information and storing all of this information. And it's processing their data, the patient's information, without the patient's consent, right? That can become a huge problem, even under the United States legal frameworks, right? So Europe is, you know, if you wanted to think about it, Europe looks at privacy here, United States looks at privacy. Depends where you sit in the world, but like differently, we'll say. It's a sectoral approach. United States, we have HIPAA and the state regulators and everyone else. So now here's the question. They come and they say, okay, class actions filed, right? Hot mess, everybody's suing everybody, everybody's blaming everybody, people are spending money like it's going out of style. And then it's all done, you lost, you got cream, she's pissed, still has her job, so grateful. And we then fast forward and there's a post-mortem. And in the post-mortem, the question becomes, what we have done. So what I'm going to offer to you are it's about it's a fact-specific exercise. Like all of law, it's a fact-specific exercise. But here's some guiding principles that if you are in healthcare and you are looking at this, these are things that you probably should be doing if you are looking at it from a legal perspective. Right, so the first thing is, there's this novel idea, it's called privacy by design. Someday, if afterwards you want to know how Barney plugs into all of that, I can tell you, but privacy by design is a principle of, from the very fundamental beginning of building this application, you are thinking about privacy. Your engineers are thinking about privacy, your business people are thinking about privacy, and the constructs that go with it. And ensuring that protecting the data in accordance with Canadian law, US law, European law, that you're following those design principles when you're building the tool. Because that will then give you a position that when you deploy the tool, that you can show a court, we acted thoughtfully and reasonably. And we thought this was the appropriate, and this is why. Now you may be right sometimes, you may be wrong other times, but it's better that you have an explanation, and better that you can demonstrate that you thought about it and you took it seriously. Next thing you should always get, obtain explicit consent. But not like that consent that's a 45-page thing that who uses the Starbucks mobile coffee app? Let's be honest, right? Who here has read the 45 pages that they tell you, we're going to steal everything, ping a cell tower every 5 minutes, and know where you are, because that is part of the Starbucks experience, right? Truthfully, probably nobody. Well, when you're dealing with healthcare and private information, getting explicit consent is important, but getting specific consent, that where you tell them, we're going to take your information about your cancer, we're going to feed it into our model, and we're going to use that to help develop and mature our model so we can treat other people better or more compelling, right? But explain it and get that consent and capture it, right? Not with the click of a button, but actually explain it to them and get that consent. That will also be a very powerful thing, both in the United States as well as abroad. Some countries you can't consent to it even if you want to, but in the United States at least, having that explicit written consent from the patient will be very powerful. And then the other thing, auditing, right? Just because, like, I'm not saying I was the best programmer in the whole wide world, but you know, they're always like, comment your code. I remember when I was starting out, comment your code. So I'd go in and put / comment. My boss really liked me a lot. I'm like, / comment. I commented it, don't worry. Right? So, and it's not that I wasn't, you know, I was an engineer. Like, you know, we invented shorthand. Like, Unix is literally a construct, LN, RM. You know, we're masters of it, right? And, you know, if you think about it, you tell your engineering team what to do, you tell the business what to do, but did you ever audit and check? I mean, who actually goes back and sees that? I can tell you nobody ever checked my code to see / comment because I probably would have gotten in a lot of trouble. I mean, but so auditing is a good practice to have. It's even more critical when you're delivering healthcare-based applications because of the biodata. Because, like in Illinois, there's this bioinformation statute where anybody, like, you can bring separate causes of action for taking people's biomarkers without their consent. Right? And you may tell your engineers, don't do it, and they're like, okay, we're not doing it. Do not worry. We're definitely not doing it. But here's the deal. To an engineer, a biomarker may be fundamentally different than what you, the lawyer, or the business people understand it to be. Right? If you show someone the color red, some people think happy, some people think blood and guts, other people think stop, other people think hot. Right? So you need to make sure that when you're doing privacy by design that everybody knows what you're talking about. And then you got to go back and check that everybody understood. Because you work in global development teams. You work in a global environment. Right? Lots of consultants, lots of other people help people implement AI systems today. Right? Just because the capabilities aren't all in-house. So you have to make sure that you're auditing that. Right? That's how you'll be, again, the courts will care. Right? Because it shows a level of diligence and a level of focus. And then develop, here's another thing, a data breach response plan, and including how to notify the individuals. So everybody probably in some fashion has an incident response plan, whether it's call somebody, call a friend, or maybe something more robust. But the principle still remains the same, right? A company that isn't able to explain to a judge why they didn't have a roadmap for when they were telling, let's say the AI really broke and it was telling patients they had cancer when they didn't. Right? That's a big problem. And then if you don't have a data breach response plan, the court's gonna be like, so let me get this straight. You learned that your AI thing was telling people they had cancer, that they didn't have cancer, but you didn't actually know who you told right and who you told wrong. Right? And then you go to the court and say, I'm sorry, Your Honor, we didn't actually think that, we didn't have a plan of how to notify and manage them, or manage that process, right? That's going to be a big deal, right? Courts, you pray to God that the courts didn't have any family or friends that actually were treated by the hospital. But then getting past that issue, right, they're going to be really focused on that, right? It seems germane, but it becomes really important. Right, so this is the basic principles that you should be thinking about when you're working with healthcare applications. Question?
Already, I was at another talk there talking about Copilot and using AI, and the Copilot, people were starting to realize that it was searching for answers within any source that it had access to. So let's say you're on a file server, and you had access to private information. You didn't even know you had access.
100%. Well, that's the whole point. That's why privacy by design is so important. So when you're building the application that you're accessing, you need to ask, is Copilot, when we're giving it access, when we're designing for privacy, what data is it looking at? Where is it pulling data from? How are we protecting that data? That's why having that, and then having the audit. So then you don't deploy the tool, and it turns out, oh, we just searched all of the CEO's personal messages with his other, not his wife, whatever. Like, I mean, bad news bear. But that's why you do the audit. That's why you do privacy by design. Now, it adds cost. It adds complication. You might not get to market as fast. But if you do those things, you'll then be able to go to the court and say, look, Your Honor, we did privacy by design. This organization, they didn't tell us that it was going out and searching everything. This is the information we relied upon, and this is how we built it. And we used good faith to do it. Question? And then you, sorry, go ahead. Who should audit? Well, nobody under the age of 10. So, that's a great question, because I teach this, and I meet all these people that say, oh, we're AI auditors. I'm like, good job. Everybody here is anointed AI auditors. Auditing AI is actually very complicated. There aren't a lot of people that are actually, in my opinion, qualified to audit the AI. There are a lot of people, though, that are qualified to audit a healthcare application to see, is it operating as represented, and test the boundary cases, and write like you a really cool PowerPoint presentation for like a whole lot of money saying, we tested this, we tested that, we looked at this, and we disclaim any liability for us being complete. But the truth is, auditing an AI-based application, you're going to have to look at the results and outcomes with boundaries. And until it gets further evolved and developed, right? It's like the airplane, right? How can you audit an airplane if you don't actually know how they build the airplane? How can you not worry about the door shaking and it's going to fall off? If the door starts shaking, you're on the airplane. What are you going to do? It's shaking. I mean, like, the audit process around the airplane industry took decades to develop. So quality controls, ISO standards, all of these things, right? And then what's an appropriate auditor? Right? Not your best friend, I'll tell you that much. Don't hire your best friend or family member to audit your AI application. At least don't make the hiring decision yourself. But in all seriousness, this is a problem. And they're going to have to evolve a set of standards and a set of controls. And you're going to need to evolve that in order to really, and the courts and the legal system and like the regulatory frame, like in Europe, they have criteria for transparency and what needs to be provided. Right, but then there's this balancing of, A, does the auditor know what they're looking at? And B, should we even give the auditor the data? And if we do give them the data, what are they going to do with the data to capture the results? So it's all a fair question. But I mean, you should just document however the process you're taking and just make sure they're not under the age of 10 and not your family member. I mean, because there is no clear standards today for auditing AI. Right? It's an evolving area at best. Another question? No. No. So that's not explicit. Not for treatment of the patient. So that can be consent for some things, but so it depends on the court and depends on where you're at. So, but if you want to have, what I'm saying is to have a solid defense, right? Get consent at the time of the collection from the patient. Now, if they're a minor, get it from if they're within, there's certain categories where certain people can't consent and other people can consent on their behalf. But make sure the end user for a healthcare-based application has consented. Now there's like healthcare billing and streamlining and healthcare apps and integrated other things that you may sign up for and click a lot of buttons and they end up sharing all of your data, or like you said, your employer may cut a deal with the insurance carrier and it may be put 20 levels deep in the plan and you're like, I didn't agree to give you that information. So there's these people called plaintiffs' lawyers. Not everybody loves them. But arguably and under some state law, that may not be sufficient. Like certainly not in the People's Republic of California. Yeah, I've seen her often. Yeah. But also, is it explicit consent if it's a service that I have to have, but they won't give it to me if I don't hit the button? So this is like my kids and like punishment. Do I care that you don't like it? I'm not consenting, go to my room. I don't care. No, no, I understand that you need to do. You need to go to your room because you need to learn not to talk back. No, explicit consent if it's a compelled service under U.S. law. Okay, so you got to be careful here. Like in certain countries, you can't do it. Like in certain European countries, that's not permitted. It may be done, but it is not permissible under certain countries' laws. Under the United States, under U.S. law, like it's called, I don't want to say coercion. There's different legal definitions for this concept, but the point is, if you don't want the service and you don't need the service, if it's a nice to have versus need, and that's a very complicated line to draw, right? It's like you go to the doctor, if you don't sign the HIPAA form, they're not going to see you, so you're going to sign the form or not, right? You can maybe go find another doctor. Okay, but I love my doctor, so I'm going to sign the form. But I mean, that's a choice. So how a court will differentiate and decide that will be a sort of a fact-based exercise. Was there one other question? Yeah.
I don't see how anything is provable. I mean, this is where I struggle with this. Let's use your example of the patient who
Cancer diagnosis.
data gets used to as part of the training data for something that determines whether or not people have cancer now treated. Well, they think that that's what happened, but does it mean, I mean, how can they prove it? Because the data is so amalgamated, there's no longer any vestige of them in the data. And does it mean every time somebody makes an allegation, the healthcare provider has to spend $100,000 to try and prove otherwise? Usually,
Well, hopefully you have a contract with the provider. But
regardless of the contract, you need some proof. Like if you're
so the proof's pretty simple, right? The proof, it's not as complicated as you think, right? If there are audit trails, so like in healthcare, specifically around healthcare and your personal health information, your PHI, okay? And if you're using that and you don't have explicit consent, right? But you'll have to be able to prove to a court that the system works like this, that here are the audit markers of standard data that goes in. Here's how the application works. And they're gonna pay experts millions of dollars to go in.
does that not paralyze the system? Let's say that
Well, no, because once you do it once or twice, you'll set a legal precedent of what is required and what is not required, which will then allow the people that are building these things to meet those standards and requirements. Right now, the problem is there aren't any. The problem right now today is that you have executive orders that have passed that set with federal temperament, right? Federal direction and guidelines or guidelines. But they set a direction, right? But once a court makes a ruling, right, and another court makes a ruling, and another court makes a ruling, you'll have a corpus of law.
But let me give you another example. I come up and I write a song or a book. You claim that it was done by an AI. I say it wasn't. How can you prove that?
Well, I'll tell you, they're litigating that now. So
How do you actually
So I'll tell you how they're litigating it, right? So I got to be careful because I'm somewhat involved in these cases. So proving these things requires an expert to, like an airplane. How do you prove the airplane takes off and land if you don't know anything about physics and gravity and aerodynamics and the plane's not going to overheat and crash or there's a whole lot of work that is done so you understand how an airplane works. That work will have to be done for AI and healthcare. And people may not like that reality, but in the United States, we do litigation.
So your assertion is that it will always be discernible to tell the difference between human-generated whatever and AI-generated.
No, my assertion, no, that's certainly not what I'm saying. What I'm telling you is for healthcare, for medical application, for treating patients, for making sure people don't have cancer, that you will need to be able to demonstrate to a level of scrutiny and standard, probably set by the FDA at some point, that your application and device isn't going to kill somebody and this is how it works. And you'll need some stamp of approval from somebody somewhere that proves that you did it. And if you don't have that stamp, you're probably going to stand up in a court of law and have a different outcome depending on what was done. Only with regards to that. I'm not making any general assertions as to the normative behavior of deep fakes or otherwise. All right, so cybersecurity scenario. So an AI-based system is compromised because of a 0 day. And we won't call it bad coding, we'll just call it a 0 day. Okay. Previously unknown vulnerability. Okay? And it has big application, big problems come out of this, right? And hackers, bypass the AI cybersecurity detection, razzle-dazzle. You know, you walk the floor, you see all those. I call them the ping, ping, ping tools, right? It bypasses all those really cool tools, right? And is able to get access to sensitive customer data, right? So what happens, right? Again, you're probably going to be sued as the person that makes the cybersecurity tool for negligence and everything else. Probably the company's getting sued for not properly managing customer information, and anybody else that they can think of suing will probably be sued. Now the question becomes, what's a reasonable posture for a company that's in this space to take to go to a court and say, look, we did what we thought was reasonable, right? There is no laws that say you have to do this. For most things outside of DFARS and the DoD, where they have more explicit requirements for building certain applications. So first thing you need to do if you're in the cybersecurity area, right, is have a framework that including security assessments. Now what's an AI cybersecurity assessment? You can go downstairs, click your heels 3 times and figure it out. It's a fluid process, right? Because it's a complicated dynamic. First off, most people selling cybersecurity AI tools don't even understand how the algorithms work, right? They don't even understand how the black box upon which they're building actually works. So assuming they know how it works, which is a big assumption in the first place, but pretending they are actual people that built the algorithm and understand how it functionally works, right? Then you can start to build a framework around it. If you license someone else's black box, you're done. I mean, you can sue them. So it's something in the United States called indemnification, which says, I'm signing a contract, I'm going to use your black box. You agree to indemnify me if I'm sued for anything because your black box sucks. Doesn't usually work so well for you, but then you buy insurance, so then the insurance will pay you money because they have insurance that basically guarantees that they won't go bankrupt and they'll cover your costs of defense and claims. Not the way to go. Understanding how the black box works will then help you at least demonstrate how you built the framework, right? It doesn't have to be perfect. There's some weird anomaly that I come across with cybersecurity professionals. The bad guys only have to be right one time, right? Any given Sunday, right? They only got to get it right once. You got to get it right all the time, but you don't. Relax. It's okay. It's like parenting. We all suck at it, just in different ways, right? The whole point is, do you have a defensible, explainable, reasonable process? Doesn't have to be perfect, right? Same is true here. Develop and implement a rapid response plan for AI-related cybersecurity matters. And this is because what we're seeing is that when you're using or trying to secure AI-based technologies, when the breach or the incident happens, it goes real fast. It just goes much quicker. You know, hackers break into your network and they like party for at least a couple weeks, sometimes a couple months, and then they pull the trigger and cause problems. In the AI sort of area, outside of state actors, the attacks tend to move much quicker right now. Now that could change, so you may or may not need to do that in the future, but it's something you should keep in the back of your mind. Update and patch. True for everything, but even more true for AI-based systems, right? And then lastly, ensure that you're complying with the data breach notification and remediation efforts that are required. Now, here's the important part. Unless you're a lawyer that's job is to do that, don't do it. Go ask the lawyers. Where you're going to get in trouble is when you try to do it and you don't know what the law is. And they say, figure it out. Be like, I'm not a lawyer. Can't. You should never assume the responsibility of figuring out how to do that without the appropriate training. It's like someone coming and say, do heart surgery. Here's a knife. Good luck. Okay, great. You're dead. I mean, like, that's just the practical reality of it. Now, that may be an awkward conversation with your boss. That may be an uncomfortable conversation with whoever, but I promise you having that conversation then will be a whole lot better than talking to a regulator or to the U.S. attorney or to whoever else is going to come down the pike and say, we're going to say, I was pressured and it was a horrible work environment, and I didn't like it, and that's why all these people ended up thinking they had cancer, and they didn't because I was afraid of my boss, right? I mean, that could be true, but you should report it. Most companies have a reporting mechanism where you can report these things, right? So you shouldn't assume the obligation of doing the notification. Question? Oh.
Lawyers are too conservative and prudent. I mean, they are really sticking to improbable causes, and you shouldn't do that.
We should stone the lawyers. So yes, so I understand the engineers' disdain for lawyers. I became a lawyer because after I sold my third company, I realized how much money they made when I paid them the legal fees to do the deal. But in all fairness, right, a truly good lawyer, so lawyers work for you. You don't work for them. Fire them. It's that simple. Right? If they're an in-house lawyer and they keep telling you no, then you go to your boss, you go to the company and say, hey, look, our legal team said we can't do it. Business, figure it out. But if you're in the position where you're hiring the lawyer and they're not giving you a solution, now if you're asking them to go out and kill someone and they say no, that's a good sign, don't do it. But I mean, most lawyers that are good, like Avi Gesser, David, like there's a handful of lawyers that will help you solve the problem, will help you think of a solution. A lawyer's job is, to sometimes deliver bad news. No, you can't go out and kill someone. But they can say, well, yes, we can do this, but you have to do it like this. Or, yes, it is possible, but you need to consider these risks. Or, here are the risks, but go ahead and do it. Just be aware it may cost us X. Right? It's like the Fen-Phen litigation from the late 90s, right? Where, basically they were killing people with this drug. And there's an email that comes out saying, I can't believe it. They told them all the risks, and there's an email that comes out. We'll write enough checks to old people as they're dying. And that's the email that was produced, and that was a business decision, and they went forward with it, right? It's about calculating risks. Question?
There's been a lot of talk about how we are able to legally use it, but there's not a lot of questions being asked of should there be certain use cases that are outlawed? I mean, up until like the 1800s, we were using cocaine to treat illness.
I think they still use it. No, I'm kidding. So his question is basically, should certain uses of AI be outlawed? So that's a state-based question. So that's a question for a country to determine, and then as a general for the globe to determine. The problem is most countries can't, look at our country. We can't determine a whole lot of right and wrong. So asking a country, and I don't disagree, but the truth is that by the time society realizes these things shouldn't be allowed, like targeting or whatever it may end up being, there'll be countries that are doing it and countries that don't, right? This is why there's no Cyber Geneva Convention, because international law is done by treaty and by customs, right? I won't burn down your house, you won't burn down my house. There's no law. There's just an understanding, right? There's not a whole lot of international law that governs cyber operations. There's a lot of customs. There's a lot of a couple treaties. And similar thing will probably happen with AI. But it's going to take 80 years? It's going to take some time, right? We're just starting our journey, right? It's going to take a long time for people to figure out we don't want X. Because to us, it makes sense, certain things, right? But to other, for example, people here would be flabbergasted to know that if you went to China, everybody here would have a social score. They know where you walk. They know what you buy. They know what you do. They know everything about you. But in China, that's an acceptable use and application by the state. But through our lens, right, I tell people all the time, this is where a lot of people struggle. It's not a right or wrong thing for them, right? Because from their perspective, through their lens, this is the appropriate way that they believe it should operate. In the United States, no. In Europe, definitely no. So but it's all relative. So when you're talking about outlawing something, you'll see states outlawing certain uses. You look in Europe, they've already called it Category 4. They've outlawed certain uses of AI, right? And so you'll see that evolve. I don't know the enforcement or how that works, but hopefully that conversation happens. I mean, at least it sounds really cool when Sam gets up and is like, we need global regulation. Yes. He, always suggests something that's unachievable. That way you're always continuing to operate. It's a good business strategy. Now, let's talk about trade secret protection. So a leading tech company, claims a competitor is using its proprietary algorithms to improve their own AI systems. Ensuing huge battle. Lawyers making millions of dollars a month. It's like a bonanza. Everybody's having a party. And it goes to court, right? Now, let's pretend in this situation, an engineering team of 10 engineers left company A, went to company B. All right? They didn't take any documents. They were good corporate citizens. They left their documents. They didn't download any data. They didn't upload it to their iCloud. They didn't put it on a USB stick. They didn't take pictures with their phone. They were like legit people. They're like, and one of the women had a photographic memory, right? But you can't, that's awesome, by the way. I worked with someone that had a photographic memory. Most useful tool ever. Especially in the practice of law, because they're like, no, that's not what it said. Fix that and that. And you're like, awesome. Don't have to look anything up. But the truth is, they go to court and litigation ensues. And now the question, and in the United States, the non-compete law, I'm sure everybody knows, FTC passed this prohibition on non-competes for not everybody in this room, but probably most of the people in some form in this room, meaning you can't stop them from going to work somewhere else. Okay, so what happens? So what do? So this is what you really need to do today. You have to have stringent access controls. You're going to have to be a lot more granular about who can see what, right, and how they can see it, and encryption, and how you're going to protect that information, the AI, the algorithms, and all of these things, right? It's going to be really important. And then you're going to have to review, you can't write and throw it away. Like, you can't write the policy, and I know nobody in IT probably reads it, but pretend they did and they implemented it, and then you don't update it. That won't fly anymore. You're going to have to regularly update your IP strategies for your AI technologies, right? I think someone asked an example earlier, how do I know that the data I uploaded wasn't shared with the masses, or the CEO wasn't able to use, I'm the intern, I go into the Copilot, how much is the CEO paying for his, or she's paying for blah, 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 right? Right? Fair question, right? But you're going to have to figure out those access controls and the strategies you're deploying if you're going to assert trade secret claim, right? And you're going to have to move quickly to deter unauthorized use of the technology, right? And so the case law around trade secret litigation is certainly evolving with AI, and it'll be really interesting to see how it plays out. But if you put these pieces in place, at least you'll be able to allege the claim. I don't know how successful you'll be, but at least you'll survive. In courts in the US, you have something called summary judgment, which basically means their claims suck, get rid of them, don't waste any more time, Your Honor, it's all garbage, right? And if you lose there, you're done, right? Well, sometimes they'll give you a right to amend, and then you can refile your complaint. But if you lose there, you're done, okay? So if you follow these general strategies, you'll probably get past summary judgment and then go before a court. I don't know how it'll turn out, but right now in AI today, one of the most valuable commodities besides computing chips is the people, right? So rest assured, this trade secrets and making sure the access controls and these pieces are in place are really critical, right? Really essential. Not super sexy, but really critical. Bias scenario. So an algorithm of an AI hiring system employed by and I'm just picking on tech companies, but you can pick anybody, a school, a university, by a university, is discovered to disproportionately favor a law school. Let's say a law school admission application. Found to disproportionately favor applicants from a specific demographic or background. Okay? Now, the Supreme Court, there's a lot of things that fall into that which make it even more interesting because of what the courts have ruled about affirmative action and these other pieces. But moving forward, the bias stems from historically admitting, or we can say, we'll stick with the example on the slides, but hiring data used to train the AI, which contains implicit bias against certain groups, right? Because we're all biased, right? Being aware of your biases is what's really going to help fix this problem, right? So what do? You implement routine audits of the algorithm. So that means having people with technical knowledge, right, to audit the algorithm to identify and correct the biases that are in there. Now, if you're buying the application, you're going to need to make sure in your contract that you get results of the audits and understanding of how it's done, right? Because I realize that most companies are like, it's like negotiating a cloud contract with the Amazon cloud. Good luck. Let me know how that goes for you, right? They're not going to largely change their terms of service. But you can require them to give you this information, so at least you have a defensible posture, right, of reliance. Then make sure whatever training set you're being fed into there includes a wide range of the demographics to reduce implicit bias, right? And there's all this literature written about it, and you can read about it. Then establish clear guidelines for the decision making to ensure fairness, right? Again, fairness is arbitrary, but at least fairness for you, and fairness from an objective standard of not just you, right? And then the last thing you need to really do is create a feedback mechanism for applicants to challenge the review of the platform. So one way to do it is to think about all these people are rejected. Well, imagine if you had an actual way for them to tell them, hey, look, your tool or our application process doesn't seem to be working right. Right, you need to investigate. So you get a feedback loop, and then you can go look at it. A lot of people just don't hear back, right? You submit a resume like pound sand, good luck, right? And people should have the opportunity to inform the employer that they think there's a bias, that the tool or whatever. You don't have to tell them, but if you can collect that data, you can more easily demonstrate, and have that information. And get input, sort of like quality control. It's like if you ever see a complaint in a dental office, it means they really screwed up. If you see an online complaint in a dental office that's legitimate, it means they really didn't do a good job. Because for someone to actually take the time to write a complaint against the dentist, the person in your mouth working on it, right, means they basically took out the wrong tooth. Right? I mean, that's the level of but similarly, you should provide some sort of iterative feedback mechanism so you can get input from the applicants or people that are participating, so you have that iterative process. So I think we're running out of time here. So we have 1 minute, so I'm gonna wrap up. If there are any last questions, I'm happy to take them. I think there was one question here, and then I think we'll wrap.
Do you foresee one of the other classes they're thinking about maybe putting large language model at the top? The large language, the separate large language model or a separate AI engine is reviewing.
You mean AI to review AI?
So you get two different AI engines. One is doing nothing but a checksum for the other, saying, hey, I see this bias or what have you.
I mean, so there's lots of ways to check for it. I mean, it certainly could work as long as it's not biased in itself, right? And I mean, it's sort of a self-fulfilling prophecy that you have to sort of navigate. But I think you should just remember that the law is evolving. It runs 10 years behind, and we're just at the start. And the policy pieces of this are like that of an airplane. Let's just all hope our doors don't shake on the way back. All right, thank you so much, and I hope you all have a great rest of your day.